Hello, everyone. That was quite the introduction to follow. A lot of pressure there. I do my best, but I am excited to speak with you all today about what Colorado's been up to. My name is Dhivahari. I work with Legislative Council staff, and for those of you who don't know, Legislative Council staff, or LCS, is sort of the legislature's nonpartisan research wing. So anytime a legislator, regardless of affiliation or ideology, has a question about anything and they want nonpartisan research on that topic, they come to us. And so I work with LCS as part of a program, a fellowship actually, the Science and Technology Policy Program Fellowship. So the Denver Museum of Nature and Science created this fellowship to essentially embed for scientists and technologists into LCS to help them with sort of scientific and tech-related legislation and sort of research from subject matter experts. So as part of that program, I am the AI and Tech Fellow, and I think I joined at a very, very interesting time because Colorado has been doing a lot with tech. We've heard about sort of regulating AI broadly, but sort of as you'll see here, Colorado has been busy. And I think that Colorado, regardless of whether or not they successfully passed bills in all of these areas, the fact that they introduced bills at all demonstrates that we're taking the first step and starting these conversations about how we should feel about these issues, which, as I've learned in my conversations with other states, we're ahead in that a lot of states they're still at the research phase. They haven't gotten to the point of introducing bills yet, or they're about to, right? And so we've actually done a lot in that way. And so these are issues that reflect trends in state legislatures across the country. And I think as we'll see, also is a response to some signaling at the federal level, right? Whether it's in absence of Congress passing a comprehensive law that would answer some of these questions. Let me postpone this for the 17th time. Whether the presidential executive orders on some of these topics have inspired or perhaps contributed to the direction that Colorado's taken. And so I think what I will do, because frankly each of these topics could warrant a presentation all on its own, what I'll do is give you sort of a bite-sized view of each of these issues. I will briefly go over sort of the high-level concerns that inspire legislators to pass bills on these topics. I'll talk about what Colorado has been doing, so what bills they passed, what bills they didn't pass. Briefly talk about why sort of certain bills passed, certain bills didn't, and maybe just sort of understanding the conversations at the Capitol when these bills were in session, and then potentially speculate as to where we're going next year. So with that, I'll go ahead and start with data privacy and surveillance. This sort of concern or interest around limiting access and use of AI tools by government agencies, especially law enforcement, is increasingly a topic of interest for state lawmakers across the nation. Geolocation data in particular, this is basically precise location data that can be retrieved from digital devices like phones and computers. Privacy over that type of data is shaping up as a new privacy concern in many states. Oregon and Maryland passed sort of were the first states to pass laws banning the sale of this data. I think Virginia considered a law. I'm not sure if they passed it. New York City as well introduced a bill a couple of years ago that would have made it illegal for cell phone companies and mobile app developers to sell location data retrieved from devices of city residents. And so I think what we can take away from that here is that consumers are increasingly concerned with and are interested in this sort of how personal data or data retrieved that they generate from their devices, from using mobile apps, from interacting on the web, on the internet, how that can influence things like targeted advertising, but more specifically, how that data can be used beyond targeted advertising, how the same data that is used by advertisers to market very precisely to you is also ending up in the hands of third-party vendors and eventually government agencies. This was definitely a question that we started to ask ourselves this legislative session. And sort of the issue of ambiguous consent over how we generate a lot of this data, and how current legal doctrine enables government agencies to purchase large amounts of data about us, and how this is collected and sold with relative obscurity is something that lawmakers are really paying a lot of attention to. LCS wrote a memo, for those of you who are interested in learning about how what tracking tools and methods third parties use to collect data from digital devices. I think what I'll do is probably send our organizers maybe a list of resources that I referenced during this presentation for you to do some further reading if you guys would so like. But I think that this memo is does a pretty good deep dive into how some of these, how some of this data is collected. Vehicle and license plate data, privacy is another huge priority for Colorado too. So this is data that is collected from sort of your flock cameras, your traffic cameras. And so as we'll see here, Colorado paid attention to these issues and attempted to address them through 3 key bills that sort of concerned in some way state government access to and sale of data with the potential to identify an individual. Senate Bill 1771, and for future reference, for those of you who may not know, the way to read this is Senate Bill 70 passed in the legislative session 2026. So that's SB 2670, same with House Bill 261037. So Senate Bill 1771 focused on heavily regulating or restricting government access to data collected by surveillance tools, focused especially on law enforcement and sort of similarly situated public safety agencies. 70 focused on data collected through automated license plate readers, or ALPRs. This was sort of informally thought of as the flock camera bill, right? These are sort of data collected through these cameras. And additionally, would have required agencies to get a warrant before accessing databases with this information if more than 72 hours passed since a crime took place. We're also putting these issues in the context of immigration enforcement, as committee members are increasingly concerned with the way that these tools can enable state agencies to cooperate with or work with federal agencies in sort of this context. That definitely framed some of the conversations we had on these 3 bills. 71 attempted to more broadly regulate law enforcement use of these tools, introducing requirements for tools like facial recognition, traffic cameras, drone cameras. The bill didn't get very far. 70 and 71 were heard in its first committee, and 70, I think, was like 8 hours of committee hearing, and at that point, I think 71 didn't just get that much and didn't move very far. So, that being said, I wanted to spend some time talking about House Bill 1037 because I think the conversations around that legislators had in committee when this bill was being heard, I think encapsulates a lot of the challenges that legislators are navigating when deciding how they feel about these topics. So, 1037 was a bill that would have regulated, or rather prohibited, government agencies from using data brokers. Data brokers are companies that build and maintain large databases with consumer information obtained from a variety of sources, including public records, publicly available sources, and perhaps more relevant to today, digital devices, right? So web and mobile app browsing activity, location data derived from devices, and so on. So, advancements in mobile app technology, the development of social media have dramatically increased the availability, variety, and volume of this data. And so brokers can use a number of technical tools to collect this information. Again, the memo that I referenced before goes into how they do this. And brokers make use of the platforms used by digital advertisers to purchase this data, which can then be licensed to government agencies. And I think one thing that we also have to keep in mind here is that there's still a lot we don't know about the data broker industry, about how this data is being collected. We're not sure that all the methods that are used are all the ones that the players in this game are using. And because I think that individuals maybe generally get a sense that, oh yeah, of course I'm being tracked on my phone. But I think people don't know exactly how and why, and that becomes important when we talk about, again, current legal doctrine that enables government agencies to use these platforms to purchase data about us that some scholars may argue would otherwise require a warrant to get. And so I think one thing that characterized a bill like 1037 from bills like 1771 were, I think, differences in awareness and knowledge from the public, from legislators, from staff. I think people, when they think of flock cameras or traffic cameras, they generally understand why that is a beneficial or harmful tool. I think it's a more, people who are concerned with things like surveillance kind of understand the visual of a flock camera and understand how that is a harmful, instrument. Versus something as obscure as sort of data brokerage, that's something that a lot of people don't really understand or can't tangibly connect with the benefits or harms. And I think that's something that we understood, right, from the questions that legislators were asking when this bill was being heard, right? A lot of just basic questions. What do we mean by data brokers? What do we mean, what data are we even talking about here? Why is data from, when you open the weather app on your phone and the weather app sends location data to X and Y and Z, how does that get to law enforcement? I don't get it. And I think that just hearing the conversations that legislators were having showed to me there's a knowledge gap here that a lot of legislators and staffers as well. I was helping staffers understand just understanding what the bill was doing, what the bill's exceptions allowed for law enforcement to do, and so that was definitely a challenge that we see frequently with legislators on tech issues at large. This is also dependent, I think, on the backgrounds of the lawmakers themselves. Some lawmakers come in with backgrounds in tech, or have access to stakeholders in the tech industry, or perhaps are attorneys with sort of experience with the constitutional issues at the heart of these bills. And a lot of them don't have any of that. And a critical part of LCS's work, including the work of the program that I'm with, involves sort of bridging that gap between these questions and for staff and legislators as well. One last thing I wanted to note before we move on is sort of the bipartisan nature of this issue. Privacy is not one that falls as neatly on the political spectrum in a way that, say, abortion would, where you kind of expect the left to believe one way, the right to believe another way. You kind of, just by looking at the legislators who sponsored all three of these bills, as well as the legislators who voted against it and in favor of it, you start to sort of identify a coalition of sort of conservatives and libertarians and progressives rallying around this interest of privacy or just restricting government access to my personal data, as well as a similarly bipartisan coalition of legislators that sort of believe in the integrity of these tools as a valid law enforcement method, right? Or sort of just around this public safety interest. And so I think one thing to keep in mind too is just knowing that in terms of who you would expect to support or reject the values behind these bills, it's not quite as partisan as one might think. And as I said, all three bills were heard in their first committee and failed, did not advance past. And I think a huge reason for that is likely a lot of stakeholding that I think the sponsors realized they needed to do, especially with law enforcement and public safety. I think, just as we had a lot of testimony from people worried about surveillance and worried about sort of threats to civil liberties, you also had, in addition to law enforcement testifying, you also had members of the community that were saying things like, hey, my brother was killed in a drive-by, and without these cameras, the police wouldn't have caught them. And so you kind of, I think that there was just a lot more stakeholding and just perhaps a lot more work that these legislators maybe feel like they need to do to get to a point where, everyone at the table can agree behind a bill with sort of the intent of these, with the values of these bills in mind. But as of now, we do not have a bill that has passed around this area. Before I go into here, am I good so far? I'm hoping to save questions until the end, just so that we have time, but are we good so far? Okay, great. I wanted to briefly step away from policing for a second and talk about an interesting case study with House Bill 1270. This was an agriculture bill, but I think that if you're interested in getting a sense of the challenges around legislating like data access and sale, I think this is an interesting example. House Bill 1270, if passed, would have established ownership rights of agricultural data for ag producers, so think like farmers, and would have established requirements for transactions involving that data. And I think that similarly, the conversations that were had during this hearing embodied some of the challenges I previously described when it comes to regulating sort of access to data. And it sort of gets into this tricky question around who owns the data about us, all right? The answer to that is not whether or not you think that is a straightforward answer. Currently, legally, that answer is not very clear, right? If we go back to this example with agriculture data, which you can think of data about livestock, soil measurements, GPS coordinates, sort of soil data collected from sensors like nutrition levels, weather data, fertilization data. All of this is, agriculture is a very data-driven industry. And even just in this scenario, you can think of, well, farmers own the land, and so they have to physically install the devices and the sensors, so clearly the data belongs to the farmers. Well, there's an argument to be made, well, the data is useless without these licensed tools to process and transform this data into something useful, so then does it belong to the tech providers? And so this is just a very small snippet into the larger question around data ownership, and I think that there's a similar question to be had, even in the previous example with regards to policing around, when we generate location data, when we use an app, does that data belong to us or not? Is there's this idea of data as a property right? Could that potentially, if we introduce legislation with that type of value in mind, could that potentially, strengthen privacy or civil liberties? And so I think that this was a very interesting bill that once again also failed in its first committee hearing. And I have to say too, we published a report on agriculture data sharing, very much expecting the interest for this bill. No one on the committee read it, and then they all asked questions that the memo answered. And I could not tell them that we had the answer. It would be like, oh man, if only we knew what ag data is. Guess we'll never know. Like, we have the answer, and they never read it. So, for my wounded heart, please read this memo. It's very informative, and I promise someone will surely care about this again. But and so with that, let's move on to a less controversial topic: data centers. So, data centers are. As I'm sure you all know, a very prominent issue, right, around regulating tech in Colorado. The very facilities that power the tools, not just, high-powered AI tools, but even sort of the daily, like a lot of our daily tasks. I think people don't think about, like, for example, video streaming. Netflix has completely outsourced its work to AWS Cloud, which is housed in a data center, and so. And this is coming at a time when local governments in Colorado are moving quickly to impose sort of moratoriums on data center development. I believe right now it's Denver, Jefferson County, and Longmont, I believe. In Colorado, we have about 56 data centers. I thought it was 56, and then I see 60, somewhere in that range. Most of these centers are concentrated in the Denver area, compared with states like Virginia that have upwards of 550, and Texas that have more than 300. And so, in anticipation, one thing you'll see is that while the introduction to my presentation was very sweet, unfortunately there's going to be a recurring theme here of legislators needing to ask us more questions, and I think that's something that we hope that they will do, especially given that we have subject matter knowledge waiting for them, very much in anticipation that the legislature will consider bills on data centers this year. We published a report, I and the other 3 fellows, so my program also has a public health fellow, an energy fellow, and a natural resources fellow, and so we each sort of contributed to a report sort of from our respective expertise. And so We published a report that I will also include in sort of a follow-up email to you all that talks about the current and frontier uses of data centers, sort of coming to, I believe we talk about job growth and concluding that there is sort of an indeterminate benefit where while there might be a lot of jobs created in constructing the data center, once the center is actually built, there's not that much human power needed to maintain those centers. We talk about energy consumption of data centers, especially the way that newer hyperscale centers consume energy, where they consume more energy for high-level computational tasks, less so for upkeep. We talk about water usage, they're pretty water consumptive, and then our public health fellow discusses sort of the implications from that perspective regarding air pollution, noise pollution, and potable water consumption. I'll send this report to you all, but keep in mind, because research on this topic moves fast, we do intend to update this with, I believe, new public health research on data centers, as well as maybe some language around difference in output depending on the type of task you're doing. For example, how much more output does a data center need to when you use ChatGPT versus when you stream on Netflix? I think that is something that could be a useful comparison to include. Colorado introduced two very different and more or less opposing bills regarding regulating data centers. We heard a lot from labor groups, the data center industry, environmental groups and stakeholders, and members of the community, including those living near proposed data center projects. And the concerns that were articulated during those hearings were about as you would expect. Concerns including impact on climate goals and water usage, potential for job creation and stimulating economic growth, potential impacts on quality of life, potential problematic implications of where the centers are placed themselves, and the potential for accelerated AI development and breakthroughs in research, especially like medical and pharmaceutical research that these data centers could help with. Once again, for more information, we have a memo on that, and I'll be sure to include that with my parting email to you all. So we saw two bills that essentially proposed very opposing regulatory approaches, neither of which made it past its first committee, a theme that we're trying not to get used to here. Senate Bill 102 was sort of our environmental friendly bill. It created requirements for large load data centers regarding development, utilities, environmental impact, and more, and created requirements for utilities that provided electricity to these data centers. Meanwhile, House Bill 1030 proposed a state sales tax exemption for data centers that met certain requirements, and the exemption, I think, could last up to 20 years, and also established a new authority to administer this exemption and ensure compliance from the centers that would receive this exemption. We are fairly certain that legislators will bring this up again, whether one or the other, I'm not sure, but I think certainly expect at least a bill on data centers. I think that issue's not going away anytime soon. Until then, I do believe the Public Utilities Commission is currently considering a proposal by Xcel to basically allow for data center growth, but include guidelines for how data centers will pay for the extra costs rather than consumers. I'm sure our energy fellow is following that a lot more closely than I am, but that's something I think to maybe look into and keep in mind. So I kind of went through two big bites. Do we feel good, or can I continue? And then again, I will leave room for questions at the end, but I just want to make sure that are you feeling good? Okay, I'm glad. Okay, AI regulation. This was, I believe, what I was contacted to talk about. We basically had a lot going on when it comes to just broadly regulating how AI is used, when it comes to impacting an individual's access to a basic need, for lack of a better word, right? And so I think that just wanting to introduce laws around this definitely sort of was in response to growing concerns around how AI is used in determining healthcare, determining housing, in the hiring process with, like, I'm sure many of my peers who are looking for jobs right now are quite demoralized by this sort of fear of like, oh, I have to try to game this algorithm, I have to try to write a resume that a machine will be okay with. The way that AI is used, can be used in determining housing. This was definitely causing a lot of concern for a lot of consumers. And so in response to those concerns, Colorado wanted to pass a law around it. And I think early on we found these challenges, not just with determining accountability when things go wrong, but also what we mean by wrong, right? Like, are we just talking about the fact that a bad outcome occurred as a result of an AI being involved, or do we want to know why, right? Do we care about things like bias? Do we care about things like discrimination algorithmically? If so, how do we do that? How do we, detect bias, especially when the tools that are used by a lot of these companies are often proprietary, and so we don't have access to the code or the training data that informs these models, which makes enforcement very difficult. And so very much this broad question of who's on the hook when things go wrong, and by what means should they be on the hook. In absence of Congress failing to pass a comprehensive AI law, states had to move quickly, though there was definitely some, signaling through executive orders from the president around sort of regulatory preferences, where I think definitely these executive orders were preferring regulation that didn't stymie innovation and didn't prevent companies from being able to innovate and develop good AI products. Prior to 2024, when Colorado did pass its AI law, states that did pass AI laws passed very narrow and specific laws. So they either passed AI laws that address specific uses, so AI in creating deepfakes, AI in employment, or states would pass laws that established task forces to research these issues. That was more or less the gist of the types of laws we were passing before. That is, of course, until 2024. So I think that anyone you would talk to will say that Colorado was the first to pass an AI law. Technically, Utah beat us by 7 days and passed a law before us, but I think that Colorado made a bigger headlines in the news because of how ambitious Colorado's law was. So when we talk about general solutions to sort of regulating AI, I was on a talk at DU recently, and the professor I was paneling with very clearly grouped the solutions in a very concise way. States are doing a bit more than this, but I think for our intents and purposes, this is a good way to understand sort of types of solutions that states can take. You could either, in the face of an AI being part of a process, like a consequential decision that impacts your access to housing or education or healthcare, states could potentially require that the people who make the models audit them, basically, conduct risk management, try to mitigate any risks of algorithmic discrimination, detecting bias where possible before these models are deployed. They could potentially allow consumers the right to sue in the case that a model has contributed to a bad outcome for an individual, or require companies to just provide disclosures, just alert, hey, just so you know, you're interacting with an AI right now, and just sort of notifying consumers when they are interacting with a model. States could do any one of these, could do a combination of these. And so with that, what did Colorado do? Well, in 2024, Colorado passed Senate Bill 24205. This was Colorado's original AI law. And this was a law that created requirements for developers, aka the creators of these models, and deployers, businesses that would use or license these tools, very much with a goal of upholding this duty of preventing algorithmic discrimination, a term that is explicitly defined in this bill, before it occurs. Companies have to identify and get ahead of risks to the extent possible. That was sort of the goal here. And so the bill introduced a lot of basically requirements for developers and deployers before a model is put out into the world, and after it's put out into the world, and sort of regularly maintaining that a model is performing well. It also introduced disclosure requirements for consumers, basically requiring that consumers know that they're interacting with a model, and providing consumers with the opportunity to correct any data involved in a bad decision. So, for example, developers had to provide a lot of technical documentation to deployers, basically telling deployers, hey, these are the reasonably foreseeable and known harmful uses and risks of algorithmic discrimination. Let me just give you a high-level summary of all the training data that we're using and the types of data that are involved in training this model. They have to tell deployers how this system was evaluated for performance and how we attempted to mitigate risk prior to deployment, what sort of data governance measures we use to cover these training data sets, and just provide a whole lot of information like that to deployers. Deployers, in turn, had to develop a risk management program to basically help ensure that they were deploying these models safely. They also had to conduct regular impact assessments that had to include things like the intended uses of the model by the business, any analysis of risks of algorithmic discrimination and ways they try to mitigate those risks. Any sort of what types of data they're using as input and output. They also had to inform consumers of that they were using this, that letting you know what we're using this model for, what's the nature of the decision, like what type of a decision are we using this model for, and so on. And also required that consumers had a right to opt out of these these systems. And in the case that something went wrong, consumers had to be able to correct any incorrect data and be given an opportunity to appeal a bad decision. So, sounds like a good idea. There was a lot of tension here. There was a lot of tension, especially between broadly speaking, civil liberties and consumer rights groups that insisted on the values behind this bill, including that the motivations of the sponsoring legislators, and with business groups in the tech industry that were concerned about how feasible these obligations were and how actually reasonable it would be for a small business to do some of these things versus, say, like a large company like Microsoft, who has a lot of the money and could easily fulfill these obligations, right? Governor Polis himself signed this bill into law, but was with a lot of reservations. And his signing letter basically said, I like the bill's intent, but I'm concerned about the impact on Colorado's ability to innovate, and I'm concerned about creating like a complex regulatory system for deployers and developers to follow. This seems like a lot. And so there was a task force that was formed through legislation in 2024 that was meant to basically speak with all of the stakeholders that had opinions about this law and create a report that summarized where these groups had consensus, where there was strong disagreement, and maybe we can use this information to create a law that address everyone's needs. To get a better sense of what those tensions were, I would highly encourage you to read the task force report. Came out in 2025, and it really goes in depth into, it's not a very long report either, it's like 4 or 5 pages, and very high level goes into exactly what these various groups agreed on and didn't agree on. I think it gives, even though the bill ultimately didn't come to pass because we replaced it with a law this year, I think it's interesting to just know the context behind, where we're at today. So, at the end of the 2024 legislative session, these various stakeholders were no closer to reaching a consensus on the AI law. After the 2025 session, the governor convened what is known as a special session. So basically, in Colorado, every state is different. In Colorado, the legislature is actively passing laws from January to like mid-May. That's called the legislative session. Every state has their own timeline and their own duration. Occasionally, when there is a need for it, the governor will convene a special session, basically during the anytime during the off session if there is a pressing need that the legislature needs to solve. When the governor convenes a special session, no one likes it because that means all the legislators have to come back to the Capitol when they thought they had 6 months off, and they have to work again. And one of the motivations behind the 2025 special session was to figure out something about this AI bill. We've been kicking it down the can. No one likes the law that, I believe the law was signed in 2024 and it was meant to go into effect beginning of 2026. And the special session, 4 bills were introduced with their own differing approaches to fixing the law. Ultimately, what we did was we kicked the can down the road again. We said, you know what, we still haven't figured it out. We're going to instead, all we're going to do is change the effective, the implementation date of the AI law to this summer, which left legislators with the 2026 legislative session to figure it out. Because if they didn't figure out what to do with the AI law, this law that many people didn't like was going to come into effect. So, to that end, actually, here, I think it was after the special session, Governor Polis convened this working group with the intent of creating a framework that would, involve extensive stakeholding with everyone that had a say, that had an opinion about the law. People in the small business sector, the tech industry, developers, deployers, civil liberties groups, consumer protection groups, to agree on a framework that could then replace the current law with something that civil liberties groups would find acceptable and developers and employers would find workable. So to that end, in mid-March, that framework came out. We basically didn't hear about the AI law until more or less the last month of session, which behind the scenes, it was definitely a little like, all right, the session's coming to a close. We haven't heard anything yet. When is it coming? Because people had a lot of strong opinions about this, and we haven't heard anything. And so, basically, the framework came out in, I think, mid-March. And that more or less became our AI law, with very minor tweaks, but more or less that framework is now what is law. So Senate Bill 26-189 was passed instead. It was passed with bipartisan support. There was no fight at all at the Capitol. I think everyone sort of got on board and agreed behind this sort of compromise, essentially. And so what did that framework do? Well, it shifted the way that we approached AI regulation, away from sort of a risk management framework towards a transparency and notice model. What I mean by that is it basically removed all of these obligations for developers and deployers prior to deployment that had to do with bias auditing. So the bias auditing requirements, the impact assessments, the risk management programs, anything that had to do with determining any sort of risk in the model prior to the model's deployment, it was scraped from the old law. Instead, companies now have to provide clear and conspicuous notice to consumers when they interact with an AI model. Developers still have to provide some technical documentation to deployers, but then otherwise just have record-keeping requirements. And then deployers, in addition to sort of that notice requirement, when a bad outcome occurs, deployers have to provide certain information to consumers within 30 days. Consumers are allowed to correct any, their data if it led to a bad decision and if faulty data was a part of it. One thing the bill does do is introduce this idea of meaningful human review, which the old bill did not do. This is a clearly defined term in the bill, which I think will be interesting when we see what agencies do with that requirement. Basically, what that means is someone must be designated to, if a consumer wants to appeal a bad decision that involved an AI, they can request someone who is a trained reviewer, someone who can't default to the system output must actually consider relevant primary evidence and has enough information about the model and data to make an informed decision to appeal any, a wrong output that led to a bad outcome for a consumer. I think another thing that was different about the new law versus the old law is sort of the type of harm we're talking about. The old law, we were talking about algorithmic discrimination. That was a clearly defined term. That term appears nowhere in the new law. Instead, we're talking about an adverse outcome. I think the way that I interpreted this change was the old law focused on specifically disparate impacts or unjust differential treatment based on any protected characteristics. It was a term that was, I think, focused on fairness, versus, I think, just a specific harmful result caused by an AI decision. In other words, I think the way I think about it is the new law says we don't really care too much about why the AI failed, it just did. And if it did, here's how we can fix it. Because I think the elimination of all the bias auditing requirements, I think, speaks to that, as well as just the definitions of algorithmic discrimination, which does focus on disparate impact based on protected characteristics. I also do wonder too if sort of this sort of focus away from the term algorithmic discrimination was designed to potentially reduce risks of sort of federal intervention. I know that we've had some executive orders that singled out Colorado's old AI explicitly as being harmful to innovation and being harmful to America's larger goal around being a leader in AI development. And that definitely, I wouldn't be surprised if that also, that federal signaling I talked about earlier potentially could have played a role there. Not sure. So that's worth thinking about. So I'm going to breeze past the rest of these just because I think it's worth talking about, but I think we're a lot less controversial. So protecting kids online. This is one that is not a very controversial tech policy priority at the Capitol. It's very bipartisan. It was an area for which I think we had the highest success rate with passing bills when it comes to sort of this goal around protecting children. We had 3 key bills here that regulated either minors' interactions with digital services and devices, or changed something about the investigatory mechanisms around these issues involving a minor. Senate Bill 51, you can broadly think of as your age attestation bill. This was a bill that basically required operating systems, when you say you get a new laptop, the operating system, when you create your account on that laptop, must ask you your age. That age, you enter in your birth date. That age is then turned into what is called an age signal. Essentially, it's turned into, if I put in my age, it'll say, okay, you're either under the age of 12, I think it's like 13 to 17, 17 to 18, above 18. And so they'll basically, the birth date that you submit, it gets turned into sort of like a bracket, and that's sort of defined as an age signal. Once that age signal is generated, they must share that signal with app developers that must consider, like, when you go on your laptop and you download an app from the App Store, any App Store, I think, on the back end, the developer must request that age signal from the operating system provider and use that to make a decision about what apps are downloaded on your device and what isn't. And the goal of this very much is to protect children from content that they shouldn't be seeing around, just like age-appropriate content. That was definitely a concern as well. In my conversations with experts that have researched this type of law more closely, my understanding is that the version that we passed is the most civil liberties friendly bill, because there are other versions of age verification bills that might ask for like proof of your age and might require submitting some sort of documentation, which then would potentially, I could see that potentially leading to like concerns around surveillance and privacy around, oh, are we essentially creating a database of, linking official documents to devices in a very like clear way. So I do believe that the age attestation, which is just sort of honor system, put in your birthday, we're not going to ask for proof of that, verifying your birthday, I think is what I understand to be like the more civil liberties friendly. It'll be interesting to see if that bill change, like if anyone decides to amend this law to make it more strict in that, like they want to ask for documentation. But as of right now, that's what we've got on the books. The chatbot bill is another one. That's House Bill 1263. This is a bill that established regulations and reporting requirements for chatbot operators and included a lot of regulations around data privacy for kids, protecting minors against sexually explicit content, mitigating negative mental health outcomes where possible, and providing parents and guardians with account management tools. Like I said, I think just the harrowing cases we've seen of minors being driven to suicide because of chatbots, I think, and just generally receiving worse mental health outcomes as a result of their interaction with chatbots, I think has motivated legislators across the aisle to sort of mobilize around this issue. And so, nationally, I think it is also a less controversial area, and definitely here it's an area for which we saw the most success. All three passed. And with overwhelming bipartisan support. Just wanted to briefly go into AI and health. The public health fellow tracked these laws more closely than I did, but I thought I'd bring it up anyway. This is another area where we saw a lot less controversy and a lot more sort of support. I don't think it was as bipartisan as protecting kids online, but still pretty close to unanimous. The Health and Human Services Committee saw two bills on AI and health. House Bill 1195 restricted the use of AI in psychotherapy services. House Bill 1139 created a regulatory structure for the use of the AI system that basically tells you when AI can and can't be used in providing health care. And I think because this area was so new to a lot of legislators, our public health fellow was hard at work providing a lot of research to them around this topic. I think in telling me how those committee hearings went, she was quite surprised by how few witnesses came to testify about these bills versus, say, the data center bills that saw witnesses turn out in droves. And this is a topic, as I said, within AI regulation for which there is strong bipartisan support. Not as much as perhaps protecting kids, but 1195 went out of the Health and Human Services Committee unanimously, and looking at the final vote in both chambers, only 2 out of 100 voted against it. So I think that says something there. And while House Bill 1139 wasn't as unanimous in the House, it still passed both chambers with bipartisan support, and more so in the Senate than the House. So. This is the last thing I'll leave you with before I get into sort of tips and tricks on keeping in touch with sort of the legislative process in Colorado. These are bills that I wasn't quite sure where to group them, but they're just bills that I think were interesting. One I wanted to spotlight was House Bill 1210, which would have prohibited surveillance pricing. For those of you who are not aware, this is essentially the question: can companies use algorithmic tools that rely on personal data or surveillance data to materially influence a product's price or an individual's wage? And companies use data-driven tools a lot to influence things like prices, fees, discounts on items, personalized offers. They can be used to determine app-based labor or gig compensation, can be used to determine wage offers. A quick glance at sort of that bill passed out of both chambers but was vetoed by Governor Polis. And a quick glance at sort of the voting records show that this was a bill that did fall along partisan lines. And the governor vetoed this bill. I think saying in his statement too that he was concerned primarily about how potentially broad the bill was, and that I think he was saying that, oh well, you know, if the goal of this bill was to protect consumers from paying higher prices because of algorithmic tools, but you could potentially punish lower prices too, because the way he was arguing, well, you know, the same tools that are increasing prices for consumers are also potentially determining discounts, and so you might actually end up, you know, leveling the playing field and potentially having Coloradans pay more for things. And he also claimed, with regards to the wage setting part specifically, that the new AI law that we just talked about, that addresses the role of AI in hiring and determining wages and employment. He also claimed that AI law is perhaps a better avenue to sort of pursue these issues, as opposed to creating a potentially broad bill. 3 states so far have targeted or prohibited the practice of surveillance pricing. I think it's Maryland, New Jersey, and Connecticut. And so it's definitely a concern that's picking up. And I think one thing that will be interesting going forward next session is that a lot's going to change. It's an election year, so obviously the executive is changing hands a lot, and that could potentially change given the Polis's voting record on some of these tech bills. But leadership in the House and Senate is also changing. The House, the Speaker of the House, Representative McCluskey, is terming out. Senate President Coleman, I believe, is staying, but the majority leader in the Senate is leaving, and he was actually the sponsor of the old AI law and technically the new one as well. He's also one with a lot of tech background, or he has a strong tech background, or stakeholds very extensively with the tech industry. 4 out of the 6 members of the Joint Technology Committee, I believe, are also terming out, and so that will kind of lead to an interesting example of, depending on who will fill those seats and sort of what perspective, like if we will see new legislators coming in with tech backgrounds, and if so, what perspectives they'll bring to regulating tech. I think that leaves a lot between changes in governorship and just all these changes in legislature. We might have a very different session next year, and we may end up making very different decisions on all of these issues based on what perspectives we see, including things like surveillance pricing, where, like I said, it passed out of both chambers only to be vetoed by the governor. There could be a chance that if a similar bill is similarly successful, that a different governor might feel differently about it, passing or rejecting a bill like that, right? So I think also, I wanted to check on time. I did include a section on tips for legislative engagement. Do we have time for that, or should we? Yeah, okay. So, that in a nutshell, the biggest nutshell ever, is sort of what Colorado's been doing with legislating tech this year. And so I wanted to leave you with some tips for legislative engagement with tools that the legislature has for you all. One of this is the LCS publications. I've been shamelessly plugging that throughout this presentation, and I urge you all to take a look. Our office does a lot of research on a lot of different topics. You can. In fact, this is an example of how you could look up research reports by topic and then subtopics within. We've done a lot of work, and we would love for more people to read them and learn from them. So heavily recommend that. This is another example of how you could sort of read into, this is all nonpartisan research as well. So this is a resource that you could definitely trust. You can also visit the General Assembly's website if you want to look up specific bills. So for example, if you go to leg.colorado.gov/bills, you can either search for bills by the bill number, by keyword, or you can even search by topic and look through there as well. So for instance, if any of the bills that I mentioned during this presentation are of interest to you, you want to see like what happened with them, what the bill was saying, I would heavily recommend this. One thing I will say actually is, most bills cost something, right? Most bills to become law have to incur some kind of cost from the government. So each bill has what is called a fiscal note, which describes that. The nice thing about our fiscal notes in Colorado is that we include a plain language summary of every bill. And so if you want to understand what a bill is doing, but you don't want to read through the very technical legalese that sometimes a bill can feel, I would recommend reading the fiscal note to clearly understand what a bill is doing. I do that a lot, to be honest, because some of these bills are like 20 pages long, and the bills that are in my area, I do unfortunately read every single word, but bills where I just kind of want to understand what the bill was trying to do, fiscal note summary, great resource. So I would heavily recommend that. During sessions, so again in Colorado, that's from January to May, like mid-May. If you want to know, and I'm realizing that the screen is a bit small, but if you ever want to know what bills are being heard in committee or on the floor on any given day during session, you can look. The Colorado display boards are open to the public. You can just Google Colorado display boards, and you should get to a page like this, where you can literally navigate to what's being heard on the House floor, on the Senate floor, what committees in the House and Senate are being heard today, and what bills are being heard in that committee. That's if any of you guys are people who are interested in sort of following a bill or testifying, and you want to track where they're at in committee. This is a good day-to-day resource that everyone in my office certainly uses. Tracking a bill's history could also be interesting if you want to know not only where a bill is at during session, but where a bill has been in previous sessions. This is also a good way to figure out if you want to listen to a committee hearing about a bill, which I highly recommend as I think one of the most important tools. If you ever want to understand like what questions lawmakers are asking, what confusions they have about a topic, what is of concern to them about anything you care about, I would highly recommend listening to the committee hearing audio for whatever bill it is that you're looking into. So the way you do that, for instance, is if you go to leg.colorado.gov/bills, you find the bill that you're looking for. You scroll down, you're going to find a table like this. You'll navigate to the tab that says Bill History, and it'll show you on what days a bill was heard in what committees. What you'll then do, so for instance, this is very hard to read, but I believe this was an AI health bill that was heard in the House, the Health and Human Services Committee on March 4th. It would show that in this table. What you would then do is go to leg.colorado.gov/watch and listen, and then you would scroll to I think where it says listen to committee audio, and you'll be navigated to a page that looks like this. The page on the right side, or the right side of the page, shows you the hearings that are being heard sort of today and on future days, but then you can also use this calendar to navigate back to a previous committee hearing. In this case, you would go to March 4th, I think I said, click on that, scroll to the specific committee that was heard in, so that was Health and Human Services, click that, and the audio should partition by bill, so you can click to the bill that you want to hear, and you should be able to hear the audio. And I do heavily recommend listening to audio just to understand where legislators are confused, and just where they have a lot of passion and interest in sort of hearing these bills. I think the conversation, the dialogue between legislators and committee members testifying, I think are one of the most educational and valuable pieces that I've come to regard in my work. So with that is my presentation. I thank you all so much for sticking around. I do realize that I gave you really huge bite-sized chunks into very, very complex topics. Please reach out to me by email or by phone if you have questions.